My name is Maurice Crespi. I'm the managing partner of Schindler's Attorneys. We're here today with Ian Fleming of Engaged, Dean Wright is my partner at Schindler's, Francois from the IQ Business Group, Peter Gordon from Engaged, and Artisha from the IQ Business Group. I see we have 15 participants, more joining. I'd ask that you guys please ask questions. The reason we have a live webinar is really so that we can actually have a discussion and we can address specific issues that you may be experiencing. Otherwise, it would be quite easy for us to do a pre-recorded show and just play it every day. And that's not the intention. So please, if you guys have any questions, start thinking of them now. And just post them on the group, we'll get to them. Peter, I'm going to kick off with you. Just a general discussion in relation to the business rescue process at a very high level. At this juncture, I just want to mention to the audience that COBRA is not about business rescue. Business rescue is a last resort. COBRA is about preventing you from going into business rescue. The idea is, and COBRA holds the view that it's unnecessary to go into business rescue, and that business rescue in the current climate is only necessary if, let's say, a landlord, a creditor is being unreasonable and says, I'm going to sue. So it's just really to level the playing fields if there is that kind of disparity in bargaining power. But COBRA is about avoiding the prospect of business rescue and trying to negotiate on your behalf through our expert mediators. But let's kick off with Peter. Peter?
Great, thanks Maurice, and good morning everybody. Business rescue, it's governed by Chapter 6 of the Companies Act. It is there to provide absolute protection, a moratorium over the company, so it gives a steel blanket over the company. Nobody can take legal action against the company for whatever matter, not only about recovering debt, whilst in business rescue. The moratorium allows, the principle of the Act is to allow the company the space and the time to try and trade out of its current predicament. The few important highlights: for a company to go into rescue, it must be financially distressed. Defined in Chapter 6 as the company cannot see its way paying its liabilities, as and when they fall due over the next 6 months, or within that 6 months period it believes that its liabilities will exceed its assets fairly valued. If either of those two are present, the directors take a vote. It requires a 50% plus one majority to agree to put the company into rescue. The directors do a resolution to that effect. They sign an affidavit, they fill in a couple of forms, file them into Companies House by way of an email, at CIPC rather, by way of an email, and the company is immediately in rescue. A line in the sand is then drawn. Everything that is owed money, any body, any organization, shareholders, staff for outstanding salaries, etc., is then frozen. Obviously, that immediately frees up some working capital for the company to fund the rescue, but often not enough. So that's another important fact, that the practitioner, once appointed, will try and find where he or she can fund this rescue, excuse me, by way of what we call post-rescue finance. Sorry, I just lost my voice there for a minute. The rescue practitioner is then obligated to put a plan together. The creditors, essentially the creditors, what we call the affected people, including the staff, have a right to vote on the plan. And the plan requires essentially a 75% majority of those creditors voting, either in person or by proxy. If that 75% cannot be achieved, there is a formal process that the practitioner and all the creditors can go through to try and get a new plan in place. And if all else fails, then the inevitable is that the company would file for liquidation. The other important thing, just broadly in rescue, is that the rescue is obviously essentially to try and rescue the company, rescue jobs, rescue stakeholders. That includes your suppliers, obviously, who are going to continue supplying you into the future. But if at any time the practitioner decides that that's not possible, then he is able to do what we call a controlled wind down, and thereby selling assets in the ordinary course of business rather than in a fire sale situation, which, in strictly speaking, should give a better dividend to the creditors than a liquidation would. And that's what the practitioner is always trying to beat in those scenarios, is beat the liquidation dividend that would go, and it's not a particularly high threshold to beat because of the fire sale situation. Company comes out of rescue when it's substantially completed, and the practitioner's got to be able to hand back a company that is financially sustainable and obviously has a solvent balance sheet and meets the solvency requirements in terms of the Companies Act. I think that's it, Maurice, if there's anything else.
Yeah. No, thank you very much. I'll say to the audience that there are various take-homes in relation to the business rescue process that are really important and you need to take note of. The first is in relation to the moratorium and contracts and liability in terms of contracts such as leases. And I'd ask Ian to just give us a rundown in relation to the moratorium, specifically in respect of leases and the notice that has to go out by the business rescue practitioner.
Thanks, Maurice. Yes, it's very important when the company goes into business rescue, the moment that a business rescue practitioner is appointed, it's very important for him to suspend the contracts that need to be suspended in business rescue. And one of those contracts is the lease agreement. The lease agreement should be suspended so that the obligations are immediately ceased. This doesn't mean that the tenant can stay there forever rent-free. However, ceasing the obligations, there has been a previous court case whereby the business rescue practitioner did not cease the contract or did not suspend the contract, and the landlord evicted him, went to court, got him evicted, and he was forced to leave the premises. So very important. And then it became a bit of a race between the business rescue practitioners and the landlords to see who could, whether the landlord could get to court first once the breach clause had expired. So very important that the business rescue practitioner suspend the lease agreement, and then what will happen is the business rescue plan will be formulated, and during that time of putting together the business rescue plan, the practitioner can then negotiate with the landlord and aim to achieve a better lease term than he had before. A more affordable.
Yeah, I think the take home there, quite importantly, is that if you're going to go the business rescue route and you're going to be utilizing a business rescue practitioner outside of the COBRA environment, make sure that the business rescue practitioner is clued up in relation to the section.
I think we've lost Maurice. I'll just continue. I think on that line, what Maurice is saying is quite critical. That the business rescue is a person is clued up in terms of the act, but then importantly is also a businessman and understands the cut and thrust of business and doesn't take either a fairly academic point of view, which you might get from, say, an accountant or a lawyer who hasn't been in business, or indeed a liquidator who's, previous insolvency practitioner who's now a rescue practitioner, who's minded to sell off as much as he can as quickly as possible. So I think that is important that one screens your business rescue practitioner before appointing, take references, speak to the bank if you've already disclosed to them that you're considering this action, speak to your lawyers. The good business rescue practitioners are in contact with those individuals and will be rated by them. The banks do keep a schedule of practitioners that they, most importantly, won't work with. So quite important to do that beforehand. Sorry, Maurice, you broke up there for a second.
No problem. I hope you can hear me now. Peter, just whilst I've got you, can you suspend? How does that work?
Sorry, Maurice, your suspend broke up there.
Suspend employment agreements?
Maurice, no, the employment contracts, it is specifically in the Act. The rights and obligations of employees are unchanged during rescue, so everything still applies. You don't affect the employment contract by merely going into rescue. If the practitioner, which he's able to do, he or she is able to do, wishes to do a formal redundancy program, they fall under Section 189 of the Labour Act, and the normal policies and procedures apply. The one thing that the practitioner does have some flexibility with is you can fast track the downsizing process, because obviously it's pretty clear that the company's in difficulty. But no other thing changed. Any negotiation that takes place with employees would be done in the normal course as it would normally be done outside of rescue.
Yeah, and if I can jump in here, Peter, just to go into more detail. If you're going to want to vary employees' terms and conditions of employment, such as by reducing their salary or hours of work, Section 189 that deals with redundancy kicks in. It's dismissals based on operational requirements. So you'd ask yourself, why would a section dealing with dismissals based on operational requirements apply to a variation of an employment agreement? The reason is you have to consult with the employee, and you have to give the employee an option to take a severance or retrenchment package in lieu of a reduction in, let's say, hours of work or salary. So you go through that process, which is problematic because we find ourselves in a situation where there's no money to pay those retrenchment packages. So there's difficulty there because the retrenchment costs may in fact be the impediment to a successful business rescue. Can you comment on that, Jan?
Yes, certainly, Maurice. We've had cases where there's certainly not enough money to pay at the end of the day, the retrenchment cost. And in that case, we've simply had to delay the payment until such stage as a particular asset was sold, or until business operations picked up again, and we could then generate money to pay the retrenchment costs. I'm not sure if you've touched on it, Maurice, but have you touched on the fact that that under business rescue we can negotiate with the employees and try and get them to reduce the cost of employment?
I did, but I'd like you to deal with it practically, because I mean this is what you do practically in every business rescue. So if you just explain how you do it as a business rescue practitioner.
Yeah, certainly. Well, in the business rescue process, after 10 days after being appointed, we need to hold a meeting with the employees to let them know what that we believe as business rescue practitioners that there's a reasonable prospect of rescuing the company. At that stage of the game, we normally start informing them of the fact that there may be retrenchments and so on, provided retrenchments are required. We'll then sit down with the employees, and what we found during the COBRA process is that employees have been very willing to negotiate and very willing to reduce their salary to an extent, often to a large extent, and with the likelihood that they'll probably still have a job at the end of the day. But yes, the employees are something that needs to be dealt with very carefully. It's a very sensitive subject, obviously. There's people's lives on the line, there's people's livelihoods and futures on the line, and it's something that has to be dealt with very carefully as part of the business rescue process.
And I think what you've mentioned previously, which I think is important, is that what you do is you come in and you try and make it variable. So what a lot of employers are doing is they're coming in and they're saying, okay, let's reduce salaries by 75%. But one cannot reject, because one doesn't know how long the shutdown is going to last for. So the idea would to rather make it variable on the basis of whatever cash comes in, or pegged to some performance indicators.
Yes, absolutely. So what we've been preaching a lot, and especially with all the hospitality industry participants that have been involved and that we've been consulting with in the last few weeks, because hospitality has been the hardest hit. What we've been preaching is moving to a variable cost business model, and this will be very much the subject of our interactions with all companies going forward. Obviously, when I talk about moving to a variable cost business model, I think a lot of the thinking that's been what we've been talking about within COBRA is that this is going to be likely a paradigm shift in the way that the world does business. And when we talk about a variable cost business model, we're talking about linking our costs to turnover. In other words, that, for example, the landlord, when you move them to an almost exclusively or a much more turnover-based rental, the landlord starts taking a lot more, he's got a much more vested interest in the company, in his tenant. So, and the same applies to salaries. And we think this is the only way it can potentially actually work, is if employees start, through this crisis, we start linking employees' remuneration to what the company is actually achieving in terms of turnover or in terms of gross profit. That's definitely one way that we can work through this process, and I can't say relatively unscathed, but with as little damage to all interested parties as possible. And employees that we've been negotiating with to date have shown interest in working according to a model like that, where their salaries are actually linked to the turnover of the company.
Yeah, in fact, we haven't encountered resistance yet in relation to that model. So it's quite important to be mindful that if you're going to be doing it, that's what, even outside of business rescue, if you're going to be following 189, that's what you should strive for. I've got a question for Dean. Dean, whilst we're on employees, can you just take us through the options now? If there is no money, what options are there with the funds?
In terms of the relief packages,
Yes.
there's quite a few, and we've got a lot of questions surrounding them, and there's lots of information on our cobra.org.za website. But the most, I think, questions we've been asked the most about is the TERS one, especially for employees, and it comes from the UIF. It's the temporary employment employee-employer schemes. And just at a very high level, firstly, to even qualify, you have to be paying your UIF, obviously. And then what it does is it creates a percentage amount of what they would be able to claim for. And one of the questions we had last week was, can I differentiate and can I claim for certain of my employees, or do I have to claim for all of my employees? And it goes down to really how much work your employees are able to do during this period, in this lockdown. Are they able to work fully at home? Then, this TERS may not be the best idea. If it's partially, they could definitely then supplement what they are able to pay their employees. And as I mentioned, it goes into a percentage, with the maximum being 38% of a 17,000 Rand. The exact amount is 17,712 Rand. And they in terms of TERS, have maximized that potential salary, and you would be entitled to 38% of that, which is an amount of about 6,700 Rand. Obviously, it's all depending on what the employee earns on a month-to-month basis. So yes, there's definitely those funds that have been put into place. There's a wealth of information, and there's everything from tourism relief funds. Just looking at some of them now, it's just been updated. There's sponsorship support schemes. There's some relief to the rental sector, which we chatted about, which is in terms of that property industry group relief packages. Also quite technical, but at a very high level, a collective scheme of the main retail and corporate real estate sectors have got together, and they've created a relief package for retail tenants, SMME retail tenants, where they could get up to between 35 and 100% relief on a discount of their rental, as well as a deferment, interest-free deferment over 6 to 9 months. There's various requirements. One of the main ones that they're looking at is that you shouldn't, and you have to undertake not to retrench anyone during the lockdown period or the relief period. But yes, so there is all that information on the website, and if they do want more, they must just send it to info@cobra. I think it's org.za, and we can.
Now, if you want to, that's how you also enter into the ecosystem. Just to mention info@cobra, then you get allocated. Well, maybe you should tell us how it works. How does the back end work?
So what happens is we obviously get an email asking for various inquiries, and it's everything on how to enter into business rescue, up to these relief packages, further information. what we do is we've got a whole team of people, basically an electronic ticketing desk, and we look at all the queries and we decide who deals with it, who's urgent, what we can just simply send the various pieces of information or point them to our the information portion of our website. Or if it is urgent and they need to meet with us, as you've said on all the other ones, we've had Zoom meetings with various parties, and we're always available to do that. That's part of this initiative, and that's why that's how we are helping the public.
Yeah, sure. If any of the attendees would like to have a private Zoom meeting as part of the pro bono initiative, you can have any one of these panelists, one or more. What we generally do is we put together a group of professionals to actually deal with your specific problems. We were dealing with employees, Peter. Now, assuming we cannot tap into the funds, and we really love our employees, and we want to put money into the business by way of a shareholders loan account to fund the salaries. Now, what I'll just jump in and say that this is possibly the one instance where we would recommend a business rescue, even if no one is knocking on the company's door. Can you take that further?
Maurice, yes, quite an important question, because this is a very classic situation certainly in owner-managed businesses. The business is struggling, so let me go and take out a personal loan, a mortgage, whatever, and stick that money into the business. When I talked earlier about post-commencement finance, any funding that goes into a company post-rescue, after it's gone into rescue, is preferred. So the practitioner needs to repay that loan or whatever funding it was, whatever nature it took, before he or she can start repaying the creditors that were in existence at the date of rescue. So if you're a shareholder and you put money in before you go into rescue, or a director puts money in before it goes into rescue, that gets frozen and is treated in the same manner as any other liability that the company had pre-rescue. If you put the money in after, literally the minute after you've gone into rescue, you're immediately preferred, and thereby have got far more chance of being repaid. The other important point to note is that there's nothing to stop the practitioner using the assets, if there's any free value in the assets of the company, to secure any further funding. That's obviously critical as regards the banks or any potential funders, because to attract them into a company in rescue is not the easiest thing in the world. But if you can offer them, firstly, the preferred status, and then secondly, security, then obviously they're far more minded to come into the rescue. So the shareholder who's put money in, taken security or not, no security, he's preferred. If he takes security, he's then super preferent. If the company then goes into liquidation, that security doesn't disappear, and the shareholder, subject to the value of the security underlying the debt, is likely to get repaid.
Thanks, Peter. Peter, now along the same thinking, in relation to what is the status of sureties, and when it comes to sureties, same consideration. If you're going to settle a surety and there's a business and it's not in business rescue, just take us through that. What is the status of sureties, and then we're going to talk about post-commencement finance.
Maurice, yes, look, it's a question that we ask certainly in the smaller to medium businesses that are considering rescue, because this is often an issue. Directors, shareholders have signed sureties normally on behalf of the bank, but not only the bank. Just be careful, because you often find that in those smaller to medium companies, people have signed surety and have forgotten that they've done so. You might have signed an operating lease over your photocopy and find there's a personal surety in there. So if you have signed a surety, obviously pre-rescue, you're on the line. If the company is failing and in breach of the loan, the suretyship can be called up by normally the bank, as I said earlier. If you're in rescue, the same still applies, but obviously the bank can't take, or the lender cannot take action against the company. So there's any other security they've got is immediately frozen. But the suretyship isn't frozen, and that's an important point. So the director, shareholder, whoever it is, the person that signed the surety, is still on the line. And then the important thing is to understand the legal terms and conditions of the security, because if it ties the individual in jointly and severally with the company, then the bank can go after the suretyship. Now, what we try and do in those situations is structure something around the bank debt, such as that we convince the bank that they'll be able to be repaid in the course of the business rescue, and that the suretyship can be cancelled, but albeit only at the end, once the bank is repaid in full, obviously. Because very often what you're trying to do is also, although it's not an obligation under the Act, it's just a practical business point. If you've got a shareholder who's a director who's running the business and he's suddenly fighting for his survival because his personal residence is under threat, you don't have the full attention of the person. And really you do want to work with the person to help you run this rescue. And that is very much a thing that Ian and I do, is a collaborative approach with the directors rather than against them, subject to them being fraudulent, of course. But, you know, try and work with them, because clearly their knowledge of the business is far superior to ours as practitioners. But yeah, the suretyship doesn't go away. If the director wishes to cancel the security prior to going to rescue, then he'd obviously have to pay the debt on behalf of the company. Now, that's also a silly thing to do if you're minded to go into rescue, and the same rules apply to what I talked earlier. Why go and settle your suretyship means you've repaid the bank, and now you owed money by the company pre-rescue, and you're going to rescue and your money's frozen. Rather do that post-rescue if you are minded to get the suretyship cancelled by repaying the bank.
We've lost Peter. Ian, he was talking around, well, let me just jump in and discuss the sureties from a practical point of view, because our courts are closed at the moment. So the courts are only entertaining urgent applications, and they are literally frozen. So when it comes to banks taking action in terms of suretyships, there's nothing they can do at the moment. And I think, look, they'd be loath to. I think they'd hopefully wait for the dust to settle. That's certainly the position of the courts. Peter, we lost you there, but you were on the question of directors. So maybe you can also dive a bit deeper into the obligations of directors in the context of business rescue.
Certainly, Maurice. Broadly, the directors' fiduciary duties that they have, and just to remind us all, that's also senior managers in terms of the 2008 Companies Act, those duties remain in place. There are some relaxations on fiduciary duties on the directors. I think it's section 75 and 76. Don't hold me to that. Maurice, you'll correct me if I'm wrong. But a director is relieved of some of his fiduciary duties, because obviously the practitioner is now in full supervisory control of the board, a court appointment who controls the board. The only person that a practitioner cannot fire from a company is a director. He's got to go to court to do that. So, and also importantly, the practitioner himself carries full fiduciary duties in terms of the Companies Act vis-a-vis the company. So it is, in our view, critical to work with, as I said earlier, rather than against the directors, and on a collaborative approach. But ultimately, if it came to a stalemate where the director or directors wish to go down one avenue and the practitioner believes that that was not in the best interests of all the affected people, defined as anybody essentially owed money by the company, including the staff, then the practitioner has the say. If the directors vehemently disagree, they can go to court to have the practitioner removed on the basis that he's not acting in the best interest of the company. But it is an important point for directors to remember that the practitioner's decision is final, and he has, if you like, a casting vote over all director decisions. But it's not our preferred route. Believe me, it just creates unnecessary difficulties in a rescue, which is the last thing you want to start creating additional hurdles in your rescue, when rescue itself is quite a challenging thing, just from a basic business point of view.
Thanks. So when it comes to the directors, I don't know if it's been mentioned, but I think it's important. How do you place a company into business rescue? It's a simple majority by the board. If they don't resolve, it's put into rescue, then, and the company is financially distressed, they have to send a notice. The board has to send a notice to creditors and employees setting out why it hasn't gone into rescue. That's why we set up COBRA, because you now have that reason. You can say we're not going into rescue because we're in COBRA. But now it's the directors who resolve, and often they're loath to resolve because they have not been that savory with the fiscus. Can you just take us through the reporting obligations and what a business rescue practitioner is obliged to do in those circumstances? But let me say this before I get onto it. The duties arise on business rescue, okay, not prior to business rescue. So the act kicks in on business rescue. Yeah?
Yes, Maurice, the business rescue practitioner in terms of Chapter 6 does have a responsibility to report any irregularity that might have been committed by management or the directors during the course of leading up to the business rescue, or any time that the business rescue practitioner finds that the directors committed these irregularities. And the Act says they have to, the BRP has to report them to the relevant authorities. It doesn't say who the relevant authorities are. So what we would do in a situation where, and remember, we're not auditors. We're not there to try and find irregularities. Our main purpose and our only real purpose is to try and rescue the company at the end of the day. But should we find irregularities, then it's our duty to report them. So what we would do in a situation where companies approach us and we either find that they have contravened SARS regulations, in other words, underdeclared tax, for example, or if they tell us that they've underdeclared tax, then it is obviously our duty to report it to the relevant authorities, and the relevant authorities in this case would be SARS. So before I start to elaborate further on this, I must just say SARS is not there to close down businesses. SARS is as concerned about employment as everybody else. SARS is not there to put the directors in jail. Trust me, SARS knows that people dodge tax. Okay, they know it, and there's ways that we deal with it. So we would go to them and we would tell them that the company is underdeclared tax to X extent, and then now SARS obviously welcomes these voluntary disclosures. You know, so we're going and we're telling them, we're opening it up to them and telling them what the story is. What we would then do as part of the business rescue is every creditor ends up taking a haircut anyway in business rescue. So in other words, every creditor's pre-business rescue balance gets reduced to a certain extent. It can be 30%, it can be 50%, it can be 80%. And then it falls upon the business rescue practitioner to pay whatever the balance is over time. So what we would do is we would negotiate with SARS, and we would come to an arrangement whereby the full balance of amount that should have been paid in the past by the directors is reduced to the extent of the haircut that SARS and other creditors take in that business rescue. So the aim is to ensure that when we approach SARS with the extent of your under-declaration or whatever, or with the disclosure of the irregularity, so to speak, that you will not at the end of the day end up paying more tax as a result of our involvement. So yes, we'll declare the additional tax to SARS, but then we'll reduce it as a result of the haircut that the creditors take under business rescue. And SARS, in our experience, has been very open to these kinds of proposals. As I said, they will agree to something that will save the company at the end. Most if prosecuted for under tax in the past, it would mean the end of the company. That is what they do. The company and they want to do the job with us as the business rescue practitioners. So hopefully that puts your minds to rest, as anybody's mind to rest who's worried about the implications of having underdeclared tax in the past.
Something we provide, COBRA provides as an alternative, excuse me, is you can look at section 155, yeah? And alternative to business rescue, and something that COBRA will gladly assist on. So what is the Section 1?
Is basically a compromise practitioner would negotiate with, or would get to understand the company and its problems, would work out the extent to which creditors need to take the haircut that I've spoken about in each class of creditors. And the Section 155 compromise differs from business rescue in that it looks at each class of creditors individually, and each class of creditors is required to vote on the plan. So, you know, you'll have your secured creditors, and then you'll have your preferent creditors being the SARS and the employees, and then you'll have your concurrent creditors. And each one of them will most likely be required to take a haircut in order for that company to survive. So the creditor, it works very much similarly to a business rescue process, except the company does not enjoy the protection of that steel blanket that Peter talks about during the time that the compromise is being negotiated. But at the end of the day, once the business rescue practitioner, or once, let's not call it a business rescue practitioner, once the turnaround practitioner in this case has negotiated with each and held a meeting with all the creditors and achieved a 75% vote in favor of the compromise of creditors, you will then you went to court and have it ratified court of the compromise is in place. So each creditors are bound by the extent to which they have the amount owed to them has been reduced in terms of the compromise. The only disadvantage, or one of the disadvantages of the Section 155 compromise, is if you have hostile creditors, if you have creditors who want to liquidate the company during the time, or want to attach, get judgments and attach assets, as the case may be. But during the time that the turnaround practitioner is negotiating the Section 155 compromise, the company does not enjoy that steel blanket of protection against legal action. So the Section 155 compromise is normally best undertaken where your creditors are fairly friendly and are willing to work with the practitioner, willing to work with the company to get the compromise done.
Thanks, Ian. Just onto the plan, Peter, I want to give you an example in relation to the voting that Ian has been making mention of. If I have a shareholder loan account in the amount of R1 million, and I'm a director, I'm the shareholder, and I have creditors who I only owe 10,000 rands to. So R1 million loan account, creditors 10,000 rands. I now feel that I'm in the driving seat when it comes to the plan, and I can put the plan together considering the value of my claim and how the creditor's claim pales in comparison. Can you comment on what would happen in those circumstances?
Maurice, yes, looks specifically covered in the Act, and the provisions of the Act are very much to protect this position where your 10,000 creditor is not treated incorrectly vis-a-vis R1 million owed to the shareholder. And how that's done is in the voting process. When the plan is approved and adopted, it needs to carry a 75% yes vote, and that's 75% of people voting either in person or by proxy. But then importantly, in this case, of that 75%, 50% of the creditors who voted have to have voted positively for the plan. So in this scenario, you've got to get 75%, which would be easy to get with R1 million shareholder vote, assuming your shareholders supports the plan. But if he votes his million and all of the creditors of 10,000 vote, you haven't achieved the 50% independent vote. And a shareholder director loan is not classed as independent. Connected parties would be intercompany loans, shareholder loans to an intercompany, parent company loans, etc. So anything of that nature, even executives lending money to the business would be classed as dependent. So if there's dependency on, or if there's a connection between the company, those votes are diluted. Now, in your example, obviously, is an extreme example, Maurice, what one would suggest to the shareholders, well, put 10,000 in post-rescue, pay out those 10,000 of creditors, and now you've got 100% of the vote, which if you're the only creditor, the dependence rules don't apply anymore, because obviously you are the only creditor. Careful there though, because sometimes people don't identify their creditors correctly, so one must make sure that you've got all the creditors correctly recorded by the time you go to take the vote. But yes, the independents would have their say.
Brilliant. Thanks, Peter. Just dealing with the plan, I think it's important to mention that within COBRA, the panelists are highly qualified individuals. For instance, Ian is a chartered accountant. And what happens in business rescue and prior to business rescue is you'll have these professionals come in and assist in putting together a plan. And that's regardless of the size of your business. We have IQ Business Group as a partner, and they are assisting with businesses, large corporations. And not only that, but the ecosystem also allows source services by others within the ecosystem. So there's an added commercial advantage coming to the ecosystem. And we must bear in mind that steps on this. It includes us launching a High Court application to place the company into liquidation, which would ordinarily cost between 30 to 50,000 rands. But on the question of fees, Ian, can you just take us through how they work, also with reference to disbursements? This is assuming it's not pro bono.
Yes, sure, Maurice. So the business rescue fees that the business rescue practitioner can charge are dictated by the Act. Now, just bear in mind that, okay, so they typically range, Chapter 6 includes the fees that the business rescue practitioner can charge. They typically range from 1,250 Rand an hour for a small company to about 2,500 Rand an hour for a large company. Before I carry on, let me just say that the way Engage has always worked and the way that COBRA works, and this ties up with what Maurice said about pro bono, the pro bono element, is that affordability is our #1 criteria when determining what fees we are going to charge. And that's very important. That ties exactly in what Maurice says. If the difference between a successful business rescue and a liquidation is the fees, then the fees will be written off to the extent that it becomes affordable for the company to undertake the business rescue. We never want to put a company in a worse position as a result of us having been there than it would have been otherwise. So the fees that are, having said that, the fees that are included in Chapter 6 are considered to be fairly outdated, the Act having been written in 2008. And typically in the case of a medium to large company that is more likely to be able to afford our fees, we'll go in and we'll say to the company, these are what our fees are, 3,000 Rand an hour or whatever the case may be. And we'll propose a contingency fee to be earned at certain milestones of the company's rescue or at the successful completion of the business rescue. In other words, a successful outcome. It's very important to define a successful outcome and to make sure that any business rescue practitioner is only charging contingency fees on actual turnaround success. These contingency fees, together with the increased hourly rate, need to be put forward to the creditors to vote on, and that's typically done at the vote to vote on the business rescue plan. But yes, affordability has to be the #1 criteria of any business rescue, and that's certainly how it works under COBRA.
The idea with COBRA is that you don't have a business rescue practitioner come in, you're left with nothing, and the business rescue practitioner in effect takes the fees from all the assets. Whilst you're on the business rescue plan, what happens if the plan fails? Like, just practically. So everybody's voted on the plan and you just can't get the plan through. I'll move to Peter just for a change. Peter?
Maurice, yes, look, this does happen. Sorry, Maurice, just to clarify, you're talking the plan's been adopted. Now you're busy implementing it and you fail in implementation.
Yes.
I had a case last year. It was a fairly marginal gold mine. The parent company, it was in rescue, and the parent company then went into rescue, and the practitioner of the parent company couldn't rescue the business, so he ended up putting in liquidation. This was an Australian, right up to Australia, where it went into administration, and we were forced to put it into liquidation. But the practitioner has to, in terms of the Act, it is a requirement to the Act, he has to, at each step of the way, decide whether he has a better chance of paying a better dividend to the creditors in rescue rather than in liquidation. As I said earlier, not a big bar to exceed. But the point is, if your plan is failing for a death type issue, then you're obligated to put it into liquidation. However, one must remember that it's a business rescue plan is, okay, it's a legally formatted document in terms of Chapter 6, but it's not vastly different from the normal strategy plan of a company. It's just a strategy plan of how to get a company to trade out of its current distressed situation. So you do have the flexibility of changing tack. If you decided, for example, we're going to try and trade these businesses and continue trading into the future, and you realize that that's impossible, you can then change tack completely and start a structured wind down of the business, and thereby paying out dividends to creditors. Those are the two extremes. The middle of it is to how do you change? You might be able to sell off a division, add a new product in. So it very much is business as usual. And you do have that flexibility. If it's a major change to the plan, so we thought we were going to trade this out and pay creditors out over the next 6 months, and we suddenly decide that we're going to have to sell off the assets because something disastrous has happened in the market, then we would go back to the creditors and advise them accordingly, and we need a 50% plus one vote on that. But yeah, it's ultimately, if it doesn't work, it is liquidation.
Sure.
In practice, the forecasts, sorry, Maurice, in practice, the forecasts very seldom pan out exactly as they were put forth, and any banker will tell you the same thing. You ask a company for their cash flow forecasts, and how often does it actually pan out exactly the same way as it was predicted? Also bear in mind that the business rescue practitioner only had 25 days to put together that rescue plan. He literally had 25 days to understand the company in its entirety, and understand all the nuances and complexities of the company, and then put together the business rescue plan, and with financial forecasts. And the rescue practitioner is required to prepare those financial forecasts based on his best knowledge and his best estimate of the cash flows going forward at that stage. But in practice, it doesn't matter how good you are. As a practitioner, you simply can't predict things like COVID-19. How could anybody have predicted that? And therefore, you'll get external and internal influences that change the way that those forecasts pan out, and hence there is often a need to revise a large change forecast. And Peter's described how that works.
Yeah, thanks for that. There hasn't been one question today, so we've got 10 minutes left. If you can direct any questions our way, that would be great.
Maurice, maybe something that I should add, which is a question that Ian and I get asked every time, especially the small and medium companies. If the directors are considering rescue, can they be held personally liable for reckless trading? Companies Act. Now, notwithstanding that Section 22, because of COVID, by just for this period, if the distressed trading and insolvent circumstances is caused by COVID, but outside of that, can a director be held personally liable? And of course, the answer is yes. If the director is traded recklessly whilst the company is distressed, then obviously the act would still apply to them. It's a bit like your suretyship question. It still applies to the director. However, the sensible thing for a director to avoid trading whilst an insolvent situation is to go into to rescue, or to go into something like COVID, where you've got a reason, a professional reason that what you're doing something here to avoid this situation continuing. But it is something that directors often question, because it is something they get quite nervous about. The other important thing there is be very, very cautious of having that board meeting, because if you've decided that you are financially distressed, as Maurice said, and you decide not to go into rescue, then in terms of the act, you have to advise your creditors. Now, I would argue that that's a daft piece of legislation, because your creditors are eventually going to be running to the court's doors to get your an application in for your liquidation. They've got to warn you about that beforehand, but still, that would be the potential outcome of telling your creditors, I can't pay you. I don't know when I'm going to be able to pay you, but we've decided not to go into rescue. Whereas if you tell them that that is the situation, but you've gone into a thing like COBRA, or that you've got some other solution to the situation rather than rescue, then your creditors are better minded not to start pursuing you through the courts.
Thanks, Peter. I just want to mention that business rescue applies to companies and closed corporations, but it does not apply to trusts or sole proprietorships or partnerships. Business rescue is exclusively for companies. But having said that, we are assisting sole proprietorships and partnerships in relation to mediating arrangements with their creditors. So it's no bar to entering COBRA in those circumstances. We still don't have any questions, but what I'd like to do now is just go through 2 examples of a business rescue that worked and one that didn't salvage the business, but resulted in a better return for creditors. So I'll start by mentioning the one in restaurant in Camps Bay, because that was simple. All that was required there was that the business rescue practitioner negotiated with the landlord, which is exactly what the business rescue practitioner did. Landlord agreed to a reduction, and the business was salvaged. And there was another Mexican fast food chain where I was really, really impressed by what Engage did. So maybe I must just ask Ian to take us through what you guys did there, and then just what happened, in relation to the first business rescue plan, and ultimately how it was dealt with. Ian?
Yeah, sure, Maurice. Yes, a very important part of our value proposition is the operational aspect. And that's certainly something that us to a large extent, existence of our business. The operation aspect in really getting involved and getting our hands dirty to do it, to make the company work. And extent, we negotiated with the landlords and got some good concessions with the landlords. And at the end of the day, and inevitably, this is most business rescues, we had to downsize to an extent. So having the restaurants out of the 5 were just such a financial drain on the business as a whole that it just wasn't, it just made no sense to keep them open at the end of the day. So we ended up closing down 2 of the branches, and the other three survived at the end of the day. And it was a successful rescue at the end of the day.
Yeah, and I think if the rescue is unsuccessful, Ian, what we've also found is that the input and the work done by, let's say, Engaged in assisting actually has helped the proprietors in their new business ventures. So they've identified where the issues are. For instance, you guys identified that the menus were a problem, and it turned out that they were a problem because there was additional revenue when you changed that. But it's also it's good to have the likes of Engaged and IQ providing the advice, including Schindler's, to when it comes to the second business. You learn a few things along the way.
Well, it's a huge learning process. Maurice, you know, we all know well to help us start from scratch, either with the necessary skills and training. As you mentioned earlier, there's a lot of end of the day in saving the business. And we certainly hope that they do, and that's our aim. They will certainly leave the COBRA ecosystem with a substantially improved skill set.
Yeah, I guess a take home from today would be, if you're going to start a new business, make sure that your employment contracts allow for variable salary in the event of an act for God. So that's something we've learned through the way, and that's something that COBRA will assist with. I think we're pretty done. We've got 2 minutes left, and I thought it'd be nice to conclude with your views on SAA, Peter.
Sure, Maurice. Yes, I always say to people who are asking about business rescue in general, one of the most difficult companies to rescue is an airline. Who's going to pay money forward for an airline that's in rescue with not being certain that you're going to be able to fly? Obviously, the black swan that has hit the practitioners of SAA is the virus, but a very difficult thing to sell off. Often the airline doesn't own its own aircraft. They're often on long-term lease, as the case with SAA. But obviously costs in a place like SAA, one can start cutting back. But as I say, there's no point in cutting back costs. I always say this, you be careful when you cut costs, because you might cut the fat out and you cut muscle by error. Doesn't help the business. But there's no point in cutting costs if your sales start diminishing. And that's what would happen in an airline. So you then have to take out whole tranches of business, as they've done, routes, etc. But when your supplier of potential post-commencement finance, being the government in this case, then turns around and tells you that they're not prepared to provide you post-commencement funding, well, I can't see any option then other than liquidation.
Yeah, those are my views as well. Great. I'd like to thank the panelists. I'd like to thank the audience. I'd like to remind the audience that to enter the ecosystem, all you have to do is send an email to info@cobra.org.za, and you'll be in the system. If you want a private Zoom session, just let us know and we'll arrange one. Yeah, and on the website, there's a lot of information, as Dean mentioned. So go to the website, www.cobra.org.za, and have a look through the material. But please feel free to direct any questions to us. Thank you all.
Thanks.
Cheers.